All right, everybody can see my screen? All right, good. All right, Mr. Leone, the floor is yours.
Well, I think Laura's going to start off.
Okay.
She's muted.
No, Laura, you're still muted.
Ladies and gentlemen, are we? Okay.
Yep. We can
It
hear
takes
you.
a village. All right. We're pleased to be here today to present you the third in a series this year. And today it's in two parts. And actually the first part of this, which is the legal update, these topics were suggested by Buddy. And I think they're great topics because they're both important. And they're also, they're ones that you can understand. They're not just a lot of lawyer jibber jabber. And John Leone will talk about that. And then for the second part of our presentation, we will be talking about things that are what we're seeing in many different types of transactions: commercial, farm and ranch, leases, just regular recurring problems where smart people like each of you don't understand these things, or your clients don't understand these things. And on top of that, many of your clients now, particularly buyers and tenants, are coming from California. And they're often very smart, mature people who understand California or New England or Illinois or somewhere else very well, but they do not understand Texas, which is very, very different. So with that, and I think we're going to try and talk no more than 45 minutes. So if you have a question, please put it in the chat. And Beth, does Google have chat the same way Zoom has chat?
Yes.
All right, great. Well, y'all know how to use your version of chat then. And John, go ahead. And John, when you finish each slide, please tell Beth to advance the slide.
You need to go to the next slide, and that'll actually start it. All right. As you all have heard, I'm sure that TREC has made some changes to the contracts, which become mandatory in use on Wednesday. So this is very, very timely. And the changes to the TREC contracts are across the board in all their contracts. And it involves primarily the public improvement districts. Now, this is kind of a very interesting thing that's up and coming in Texas, municipalities, counties, and even smaller jurisdictions within counties about a mechanism that they can use called the public improvement district. Let me go through the three changes in the contract real quick, and then we'll get into detail about a public improvement district. But what they have changed is on paragraph 6, subparagraph E7. You know, there had been a prior notice in there about public improvement projects. Nobody really knew what they were, but the legislature actually did pass some laws this session when they were all in, when they had a quorum. So what they did is they now required and amended the local government code to require that public improvement districts need to have a separate notification in writing signed by all buyers pursuant to a contract if that property is in a public improvement district. And the other change they made there was in paragraph 22. It adds the addendum, and the addendum is entitled a Notice of Obligation to Pay Improvement District Assessment. Those become mandatory on Wednesday. You cannot use them before that because the effective date of the law that was passed is September 1st, 2021. So starting Wednesday, the new contract with that language has got to be used, and if the public improvement district applies, it has to be attached as an addendum. It's a separate form. And I'm sure you've seen that form, and it's really a simple form. It's just like the MUD forms you've seen, or the WCID forms you've seen that deal with those sorts of districts as well. It just says, as a purchaser of property, your property is subject to assessments because it's in a public improvement district, and it tells you who to contact about it and so on. And that information is discernible as you do as far as finding out information about MUDs and WCIDs, water control improvement districts. So it's a one-page form, will have to be attached to the contract starting Wednesday, if in fact the property is in a public improvement district. Now, I don't know how many of you have been involved in contracts that have previously been in a public improvement district. It's kind of an up-and-coming thing. The law was originally passed in 2006 to provide certain counties a way to raise money to put in amenities that was then passed on to the landowners in that section. But this recent amendment has brought it to the forefront, and I think we're going to be seeing a lot more public improvement districts in the future. Now, what is it? It's defined in the Texas Local Government Code, and basically it's a designated geographical area in which people want to put certain improvements. Now, this district, a public improvement district, comes into existence by petitioning either the city or the county in which it's located. Any group of individuals can get together, file a petition, pay the fee, and seek to have certain improvements done. Now, the interesting thing is the act goes on to define what improvements can a public utility district allow to be built. And usually it's funded by the passage of bonds, and there's always going to be a public hearing on the bond issue, whether the bond should be approved and voted on. But the public improvement project, it goes well beyond what a MUD does, which is provide water and sewer for a subdivision, or a water control improvement district, as you see WCIDs, that control the runoff water and make improvements as far as how that is handled. This statute allows any group to petition and get into that district. It can be for landscaping. It can be for the erection of fountains, distinctive lightings, signs, like decorative entrances to subdivisions. It can provide for sidewalks, driveways, pedestrian malls, off-street parking facilities. It has a specific category. It can be for the acquisition and installation of pieces of art, mass transportation facilities, like local areas that are designated for mass transit to come through. It can also be used for the expansion of affordable housing. So this, and then it goes on to say, and any other similar type improvements as those listed. So districts get fairly creative about what they may want to do. I know that in San Antonio, there's one that was started for a skate park, and a certain couple of subdivisions got together, formed a public improvement district, came up with a cost estimate, passed a bond, and now there's a skate park that's available for the people in that area. So it's an interesting concept. It's being expanded by this new revision to the law. And it's going to be something that we're going to have to be on the lookout for, and sellers are going to have to be aware of. They are, once they are approved and the improvement started, there's like a monthly assessment that's not a property tax, but it's an additional fee that is charged to the landowners that they either pay monthly or they can pay it in whole to pay it off. And we have to be aware of that because there's going to be more and more of those. You have to be on top of asking sellers, are you in a public improvement district? Hopefully they will know. People that don't pay attention may not be aware that they've gotten notices about, hey, you're going to be in a public improvement district. We're going to have a meeting. We're going to authorize various construction improvements in this geographical area, and there will be a bond issue, and you will be assessed a certain amount. And these could get quite extensive. So I checked the Travis County site. There's 107 districts in Texas that kind of qualify under these three statutes. Obviously, I think 100 of them were municipal utility districts themselves and the water control improvement districts, but there were 6 or 7 others designated, usually in the names of subdivisions. Now, this vehicle is also available for homeowners associations, which I find extremely interesting. So any property owners association or any 2 or 3 property owners associations can get together, and they could actually build a park with additional pools and amenities and have it funded by all the property owners and have access to it. So I think we're going to be seeing a lot more of that. I'm dealing with a subdivision now that's having problems with the developer, and it started out, everybody was happy. It started with a couple of subdivisions, and obviously the builder put in some improvements and a couple of swimming pools. They have now added 8 more sections of subdivision to it and have not increased the amenities. So this would be a perfect example of how that property owners association, along with some others, could get together, form this district, get amenities passed, additional pools and so on for use of the residents. So I think that's a very interesting change to the law that's come about. The only other change to the contract itself, besides those 2 in paragraph 6 and paragraph 22, it's in paragraph 7H under residential service contracts. And this is a very minor change. It's not going to have any impact on you, but the sunset law came into effect once the residential service companies were originally licensed by TREC. That statute is expired. Now residential service companies are going to be governed by the Texas Department of Licensing and Regulation. That's the only difference. So TREC is now out of the business of licensing residential service companies. It's going under another governmental program, licensing and regulation. Those are the only changes to the contract that are taking effect September 1st. Now,
John,
yes,
we have a couple of questions. Is it a good time to stop?
yeah, on public improvement district, I agree.
Okay.
Now would be a good time to get a few questions.
Okay, Laura, I'll start with you. You got your hand raised?
Oh, no, Laura was just trying to figure out how to use the chat.
Okay, I got the chat. So question from Jackie, John. She said, you mentioned the form that needs to tell the buyer who to contact if the house is in a PID. The notice to prospective buyer in zip forms does not give that info or a place to add that information. Do you know which form we should use and where do we find it?
Well, it's TREC form 53.0. It's on the TREC site, official site under documents. It's listed there. And that's where I printed this one off from. And that form, it's a very simple 1-page form. And it goes on to say, and this is important, it says, the undersigned purchaser acknowledges receipt of this notice before the effective date of a binding contract for the purchase of real estate. So it has to be with the initial, offer to the seller. It's got to be included with that before the contract can become binding. But it is on the TREC website.
It will probably be on zip forms if they're not effective till September 1st. It may not be in zip forms till tomorrow. So
yeah, because they don't want you to use it now because the law is not in effect yet.
right.
So you literally cannot use this addendum before September 1st. You can start using it 12:01 midnight Wednesday if you are up and doing that.
All right. Next question is from Paul. It says, is the Travis County website where we find a list of PIDs? The HOA, if present, should also know about PIDs in a subdivision?
Oh yeah, there's no question the property owners association would have to know about it because if it's in a PID, then every resident in the subdivision is being assessed a payment and they have to pay for it. So I would find it shocking if the property owners association does not know that they're in a PID.
Okay. And then from Scott says, how can we verify that a property is in a PID? Comments on TREC website said if it's not broken out in the tax roll for the property. I'm not sure I understand that question.
Well, and that's a good question. It should be broken out by the Travis County tax appraiser or the county appraiser as far as an assessment, just like a WCID is. It shows up on your taxes. If not, you can go to Travis I just went to Travis County Public Improvement Districts and typed it in, and a list of 107 came up. Again, most of them were MUDs and WCIDs, but it does list all the others. So you can always do that. Very simple to do.
And one last question. What is the name of the form again?
Oh, it's a complicated name. I can't remember it. It is called the Addendum Containing Notice of Obligation to Pay Improvement District. That's the official name from TREC.
Thank you, John. Does anybody else have any questions before we move on?
Okay, well, I will move on with the exciting legislative changes that have been made that might affect your business that you need to know about. The first one is floodplain notice. There's a statute passed that says a landlord must now give notice to a tenant if the property is either flooded within the past 5 years or is within the 100-year floodplain. And, you know, that's going to be required. Now, that law is the only one I'm going to talk about today that does not take effect until January 1st, 2022. And I have seen no forms yet as to what a notice from a landlord to a tenant would look like. I think we'll start seeing those show up, but the statute is very specific. It says the landlord is or is not aware that the dwelling you are renting is located in a 100-year floodplain or that it has flooded in the past 5 years. Now, the interesting thing about this statute is you would say, well, most statutes should have a remedy. What happens if the landlord doesn't do that? The only remedy set forth in this statute is if the landlord does not do that, the property is flooded in the last 5 years or is in a 100-year floodplain, and it floods again and the tenant loses property or gets flooded, his only remedy is to give 30 days notice to terminate the lease. That's all it says. It doesn't say anything about damages. And of course, I think, you know, you can sue the landlord for damages just under general contract law because he had an obligation that he didn't comply with. But it's kind of interesting that that's the only remedy the tenant has, is only if he floods does he, you know, is he entitled to terminate the contract? And then he still has to give 30 days notice of the termination. It doesn't stop him from being responsible for rent or anything else. So it'll be interesting to see how this statute plays out. It was added to the property code as an entirely new statute. And by the way, it only involves, sometimes people confuse flooding with water from a hot water heater and that sort of thing. It only involves flooding from either a rain event or water backing up and drainage issues. It has nothing to do with water coming from inside or a roof leak or anything like that. That is not considered flooding according to this statute. So again, it's kind of interesting. It's not going to take effect till next year. We'll just kind of update you if and when we see a form that comes out regarding it's attached to leases that will cover this issue. The next statute passed is extremely interesting. I don't know the thought process behind it, but it does. Oh, yeah, it does give you the option. The landlord has the option, instead of collecting a security deposit, to collect a non-refundable regular recurring fee. So what that means is if the landlord wants to offer this to the tenant, instead of a security deposit of say $2,500, he can come up with a dollar amount that he charges the tenant each month that's paid along with the rent as this reoccurring fee that's non-refundable that the landlord gets to keep. I said, I don't know. I'd love to know if someone knows the background of why the statute came into being. The statute goes on to talk about that the fee has got to be paid each month. It's a separate fee, and if that fee is paid at the end of the termination of the lease, then that's it. There's no security deposit. There's no accounting for a security deposit. The tenant doesn't get anything back, and it doesn't say if the landlord can still file suit for excessive damages. I don't think he can. And the reason I say that is because in the statute itself, it says specifically that the landlord can use this fee to buy insurance protection against damages and non-payment of rent, almost like a business interruption insurance type policy that would protect the landlord for damages and non-payment of rent if the tenant defaults. It says that the tenant has the option, if the landlord gives this option of a recurring and non-refundable fee or a security deposit, the tenant can opt to either do it or not do it. The landlord cannot enforce that recurring fee on the tenant. The tenant says, no, I don't want to do that recurring fee. He can still do a security deposit, and that's what the landlord has to do. But it is a non-refundable fee in addition to rent. And like I said, again, that'll be interesting to see how that pans out. If you've got a lot of landlords, and I don't know how they would determine what that fee is. The statute specifically says it's a fee set by the landlord himself. So if you normally would rent the property for $2,500 a month and collect a deposit of $2,500, a security deposit, I guess the landlord could charge a $100 non-recurring fee a month and move forward with that and not have to mess with the security deposit issue. And I think part of this came about, I think landlords were getting kind of tired of being sued by not giving back security deposits, even if they had legitimate charges. And I've seen more and more of that where, the landlords are being sued by tenants who have basically nothing to lose, and the landlord's got to take time and money to defend what he did. And a lot of times they're not real good about taking pictures, documenting expenses, and so on. So this gives the landlord an option to avoid the whole hassle with a security deposit if the tenant's willing to pay this fee. And I guess it technically takes the tenant off the hook if the tenant's really rough on property or has 14 children. They could cause a lot of damage to property. And by paying his reoccurring fee, he kind of limits what he's out. So it'll be interesting to see how this statute comes about and how it actually works in reality. But it's a very interesting one, and I'm sure those of you that have landlords may start getting questions about what does this mean.
Yeah, we have a couple of questions on this as well.
Yeah, and this is also in the property code, section 111 of the property code. So I'm sure there's a lot of questions about this, and admittedly, I have not seen much about it other than read the statute. So I'll see if I can answer your questions.
All right. They're both similar. The first one is they can only do one or the other. They can't do both.
That's correct. One or the other.
Okay. And then the second one is from Jackie. Is there wording that says either, just keeping it clear so the landlords cannot charge both? Where would they find wording for that?
Well, that's a good question. It doesn't say, the statute specifically does not say that they can't do both, but it says, it puts it out as options. The landlord may either do this or that. And if the landlord offers the non-refundable recurring fee to the tenant doesn't have to accept it. If he turns that down, then he goes back to a regular security deposit. So I think the statute, the way it's worded, talks about it in terms of options, which makes it pretty clear to me that you can't do both.
Okay. And the next question, and I'm not sure, Scott says, will the lease form be updated?
That's a good question. I don't know the answer to that. Like I said, I didn't even know about this until the legislative updates came out. I had not heard anything about it. I usually hear about various changes that are being considered, but this was just caught me by surprise. So I'm sure there will be changes. There has to be, because when you have the recurring fee that's non-refundable, it says it has to be in writing, signed by the landlord and the tenant. So obviously there will be a form coming out that will address this issue. If and when I see and get one, I will certainly forward it over. And likewise, if any of you see one, include me in a copy, okay? Like I said, it's a very interesting change that I never read anything about preparatory to this taking effect September 1st.
That's all the questions. Oh, there's one more. Must the landlord use the fee to buy insurance, or can it be used however the landlord desires?
Nope, he's not required to buy insurance. That's what's very interesting about the statute. It says that the landlord may use it to buy insurance. May is not mandatory language. So to say he may, he doesn't have to. He's not required to buy insurance. He can just keep it as his at that point. Each month when he gets it, it can be his. And he runs the risk that there may be damages to the property at the end.
All right, that's all the questions for that.
Okay. The next change to the legislative changes is kind of interesting, and I don't. It has to do with the Texas Fair Housing Law. And what they did is they passed an act to bring it into compliance with the Federal Fair Housing Act. And the Federal Fair Housing Act does not apply to individuals if they own 3 properties or less. And a lot of people were not aware of that. But the Texas Fair Housing Act specifically says, you cannot discriminate on race, religion, ethnicity, and all the other things that are protected. But they went ahead and passed the statute that exempts from compliance with that provision any owner who does not own more than 3 single-family houses at one time, and when he sells or rents it, he does not use a real estate agent, broker, or any other party. So if an individual has 2 houses and he puts it up for rent or sale, he is not required to comply with the fair housing requirements. So if you represent a buyer in a lease, the owner can do what he wants. He doesn't have to give a reason for it because he's not covered by either the Federal Fair Housing Act or the Texas Fair Housing Act after September 1st. They are totally exempted as long as 3 houses or less they own, and they don't use a third-party real estate agent, broker, or other company to advertise or assist or negotiate in the sale or rental. Interesting change. Any questions about that one?
I don't see any.
Okay. The next change, again, what rights do elderly people have against real estate agents? And they passed the statute. We've been hearing so much more these days about elder abuse and people taking advantage of older people, and obviously for financial gain. And so they have amended and passed this statute that makes it a criminal offense for financial abuse of an elderly individual. Now, financial abuse includes 2 things, and it means wrongful taking, appreciation of obtaining, taking of any property of a person that's protected by the statute. And when they talk about elderly, it's defined in the law as someone over, I believe it's age 60. They also define financial exploitation, and that's what they added to this act. Financial exploitation is the wrongful taking, obtaining, retaining of money or other property of elderly people by a person who has a relationship of confidence or trust with the other person. Now that includes parents, children, guardians, anybody with a power of attorney, and who else has a relationship. And it goes on to say it actually uses the word fiduciary relationship in another section of the act. And who has a fiduciary relationship with people? Real estate agents. Once you sign a listing agreement or anything else, you have a fiduciary relationship to them. So if somehow you did something that resulted in financial exploitation of an elderly person, and you are a real estate agent, you breach that fiduciary duty, and you can be liable under the act. Laura, you have a comment?
Yes, some people are not aware that in Texas, the term elderly person the term elderly person has nothing to do with whether they're incompetent or have limited disability. If you meet the definition of 65 or older, you have every one of these protective rights, even if you're fully capable and much better educated than whoever it is, an agent, a lawyer, a business partner. These are very powerful rights in several sections of our codes that are not typical in other states. So all of you who look so young and lovely and aren't 65 years old, look what you got to look forward to. You could just take the world by the throat once you hit the big 6'5". But that's very important to know. At 6'5", they have all these rights.
Yeah, and just to echo it, this is a criminal statute. It goes and says if you're found guilty of this, you can go to jail for that. Now it goes on and defines, taking financial exploitation can be a parent, it can be a spouse, it can be an adult child or other relative by blood or marriage, or the people that have a fiduciary relationship. So I can't imagine how that might involve a real estate agent other than agreeing with the children of the parent to sell the property quickly to get money out of the estate. I mean, out of what would eventually be the estate. And if it's not full market value, someone could bring a charge against you under the statute, financial exploitation. So you got to be careful of circumstances, who wants you to do what. I've had many times where agents have taken a listing. The owner of the property is an older person above 65. And they say, well, talk to my son about this. Talk to my niece about this. And so all your negotiations are through this other party, not the actual owner. Well, you could technically run afoul of this statute by not running everything by the title owner themselves, even though you've been specifically asked, don't talk to me about it. I think you've got an obligation to do that because taking directions from someone else who's got other concerns and may have an overriding interest to get the property sold could run afoul of the statute if the actual owner decides, hey, I qualify under the statute and I think I've been exploited. And financial exploitation, that's a very broad-based term. It doesn't have any financial value on it. Just if you've been exploited to some extent, you could be liable under the statute. So, like I said, I think it's a very interesting change. It'd be interesting to see what comes about in the future on that.
John, may I say one more thing?
Yes.
And particularly our clients that are up in y'all have a big group that serve the Williamson and Bell area where there are tremendous number of older persons. The farm, I call it the Farm and Ranch Club, these families that were simple people, ranchers, who a few years ago were still trying to figure out how to make their tractor payment. And now they find a stunning offers made to them to buy their largely unimproved land. And I just want to say to you, it's a real temptation when somebody comes to you and wants you to help them sell $20 million worth of land, and the older person who's still the record title owner, Big Daddy or Big Mama, is who's the only record title owner and who the title company is going to require to sign everything. And yet they, in your professional opinion, are not competent. And they are competent enough to tell you simply, I want my children to handle it. Well, if those children don't have powers of attorney, if they do not have, and if the parent didn't sign that power of attorney when he or she was still competent, and you take on and rely solely on the children, and later someone comes back at you, even if it was a great sale, you breached your fiduciary duty. And I want you all to think very long and hard about that, because a breach of fiduciary duty in a setting like that with big dollars is something that could cause you to have your license revoked. This is one of, now this elderly person statute targeting real estate agents And there are other groups that are also fiduciaries, made fiduciaries in their dealings with elderly people. But this is one of the most extreme statutes in the United States for that. So if you have an elderly person and they don't appear to be competent, and you've always got to remind yourself, we all grow less competent over time. Not all, but many grow less competent over time. What is your proof that at the time you received directive for this person, just deal with my children, here's my power of attorney? What is your proof a year or two later if things blow up? And these big land deals are taking some of them a couple of years, because these builders have a long runway before they're willing to close. So that's just a word to the wise. This is a strongly worded, it's an unusual statute. John, we ought to do a little research on what happened. That, you know, bad facts make for bad law. And I bet there's some bad facts that led to this targeting real estate agents. But always be asking yourself, if your real client is an elderly person who appears infirm, take some steps. And there are things you can easily do. We help people with this all the time. We record and we confer and we make notes at the time you are retained. And once you're retained, then it gets a lot easier. But if you don't take these steps and you just start dealing with people's nephews and nieces and children, and something goes awry, you're going to be badly exposed. More so now that this new statute's been enacted. Sorry to interrupt, John. Go ahead.
Just as a sideline, when I was doing some real estate closings, I had some kids bring their mother in to sign the contract to sell the property. And I had some questions about her ability. So I literally sent the two kids out of the room and sat solely with the mother and my legal secretary and talked to her to make sure I felt comfortable that she knew what she was doing. Because a lot of times people don't. I mean, the kids came in and said, "Mom, sign here." Mm-hmm. You know, and that if that happens, you've got to take some time and make sure the person you're dealing with is competent, at least in your mind, to make the decisions to go forward with these things. Two other changes in the legislature were made that you may run into, and one is they greatly amended Section 202 of the Property Code that deals with homeowners associations. I don't know if any of you have run into it, but some homeowners associations like to push the limits of their authority. Let's put it that way. I haven't been involved in a bunch of cases lately about that. But what they did do that's extremely important is they have limited the amount that a homeowners association can charge for copies of the relevant documents they're required to produce under the contract to no more than $375. And they've limited the amount that an HOA can charge for a resale certificate or reissuance of another one to $75. I've seen lots of closings when I've looked at closing statements for clients in which HOAs were charging well in advance of that. I saw one charge $1,500 for copies of the documents. Well, there were no limits on it, so they have limited it because it was subject to such abuse. There were huge fees having to be paid to close and transfer property that, in all honesty, aren't justified. How long does it take to make a copy of the formation documents for an HOA? You got the certificate of formation, the bylaws, the covenants, conditions, and restrictions, and some amendments to it. So they brought those fees back into line where those are maximums to be charged, which you should note on the closing statement. So if you're looking at closing statements for your client, they're asking, what's this fee? Just be aware that resale certificate fees are limited to $75 after September 1st, and copies of subdivision documents are limited to $375. So that's a good one. The next one.
John.
Yes.
Sorry, we have one back step for a minute. I believe Diane had a question about the elderly thing. And I think Laura mentioned a little bit about it, and Diane, you can unmute if I don't get it right. She said, what if the elder person is present when you're having the meetings? Is there any way to cover and protect the agent?
Well, it gets, John, if I may, it gets back to what do you have to protect yourself that a reasonable person, this is not a medical decision. Would a reasonable person believe the person was competent? And to just bring somebody into a meeting, like John said, and they just sit there while the children do all the talking, that's not going to work. Because many times what we have are will challenges or document challenges. And several years later, that person who was already very elderly, but perfectly competent at the time, no longer is elderly. So there's several things. And you really, you have to use some finesse in this, or you will offend everyone and lose your client. You need to make the point to the children, I'm doing this to help this transaction go through. And I don't have any problem at all. You're absolutely within your rights. What we usually do, this idiotic thing you may have seen if you had an elderly loved one in the hospital, we all have, where these people, these nurses and other healthcare providers bound into the elderly person and start asking them, who's the president of the United States? When was the Civil War? All these things that just frighten them. And then they freeze up. That's not what we do. We bring them in and and it's perfectly reasonable. If the record title owner is an elderly person, that's the only person who's going to be required on the listing agreement, unless there's a power of attorney. And at that point, you have a pleasant, like John said, you have a pleasant conversation. And if the children start coaxing that person, that tells you something right there. So, and if you're concerned about it, if you can get all the other parties to shut up and tell them, we're not going to film this with a cell phone, as long as you tell people you're doing it and know how to ask the right questions. In fact, John, we ought to do a little video for everybody on how to pleasantly and professionally prove up that your record title owner is competent. But remember, the day of reckoning is not going to be the day after that interview. It's going to be a year or two later. And that's where it will have served you well if that person can have a little talk like John had with his client. And then I would urge you, that was before videotapes were so common, to then videotape it with everybody there. That's much more powerful than some medical doctor that the other side puts up, an heir who's unhappy about something 2 years later, trying to conclude whether the person was competent or not. But it is, make no mistake, it is a fact question, and it requires great delicacy. Maybe we ought to have a little update on that one, Beth. That'd be fun. I could cross-examine John Leone. Hey, John, how old are you?
Older than you.
John, ladies and gentlemen, meets the definition of elderly. So do I. Hey, elderly can depose elderly for our next up-and-coming presentation, John.
Okay.
I'm sorry. Go ahead.
Hopefully I'm semi-competent. At any rate, there's one more legislative change I want to mention. It seems extremely minor, but they passed a statute that says an air conditioning system warranty automatically changes to the new owner upon closing the sale of the property. It does not expire. And apparently there used to be a lot of AC warranties that when issued, people would put in a new AC before closing, sell it, and the warranty specifically said is not transferable upon sale of the property. So they've gone back and corrected that. I actually ran into that situation once where someone bought a house, the air conditioner was allegedly new with a warranty, and we read the warranty and it did not transfer upon sale of the property. So that has now been changed. It automatically transfers to a new owner upon the sale.
Okay. Beth, I believe we had one more. I just saw that.
We have a couple of questions.
Okay.
So Jack, does this apply to the transfer fee? Was that back on the,
Yes.
the
Yes,
HOA?
the transfer fee. I wanted to know if you could clarify the transfer fee. Some places charge like $1,000 transfer fee. And is that limited now to $75?
No, it's the transfer fee. The only thing that the statute limits is copies of the documents that are required and the resale certificate. Those are the only two They limited. They did not limit in this statute the transfer fee.
Okay, thank you.
Okay, thank you. Holly, I don't understand your question. It says medical records 10 years. Do you want to unmute and clarify? Okay. Susie has a question. She said, can we go back to the appraisal report? We might have skipped that one on your sheet.
Yeah, I was waiting to see if anybody was paying attention, but yes, you're right. They passed a statute that specifically said that appraiser is now called an evaluation, which is less extensive than an appraisal. And so it's going to be interesting to see how many lenders will be willing to take an evaluation instead of a full appraisal on the sale of properties. They say it's done so it can limit the cost on small conveyances, small tracts of property, and the less expensive real estate. So you don't have to pay for a full appraisal. It'll be an evaluation. Now, I don't know what that form would look like at this point. The statute just came into effect. Will come into effect September 1st, but it does provide for an alternative means instead of a full-scale appraisal to get an evaluation from a licensed appraiser.
Can I add one thing to that? This is very significant. We have what some people characterize as a crisis in terms of a lack of available certified, me if I'm wrong, but over the last few years, it has been absolutely unlawful for a certified appraiser to do anything for which he did not apply his seal. And the tenets of the appraisal board were such that there were a number of activities that had to occur before it was a very significant and time-consuming process. So, John, what I am assuming, and I haven't seen the detail come out of the appraisal board yet, is that this new report is, I won't say more superficial, but less elaborate, and consequently the big problem we have, which is getting an appraisal report takes months. There will be fewer things the appraiser has to do, but may still apply their seal to the report or recommendation or whatever it is. Now, but I just want to say, we all remember TREC has not changed and the legislature have not changed anything about real estate agents may do comparables, but may not give an opinion regarding appraised value. Only a certified appraiser may do that, and that too is a grievable offense.
So there's also a question, does the appraisal eval apply to the new builds?
Well, I think what we need to do, even though this law goes into effect September 1, right, John?
That's right.
We've got to look at what the appraisal board, for its certified appraisal experts, what they're going to require them to do. Because if you look at what must occur, the contents of an appraisal report are very precisely defined. And this thing that the new law allows, I have not even seen anything addressed by the appraisal board yet as to what goes into it. So I think that's a stay tuned for more question. Right. Yeah.
One more question, Holly. Can you unmute and clarify your question, please?
Yes. If the plaintiffs do file a lawsuit, they have access to 10 years of medical records. Is that correct?
You mean
for the elderly person?
No.
Well, this was a 10-minute back.
What anyone would have a right to as a plaintiff depends entirely upon what they're complaining about as a plaintiff. No one just files a lawsuit and then has a right to carte blanche for somebody's medical records. Those are intensely protected. So they wouldn't even necessarily have a right to current medical records if their allegation was about one type of disability versus another. So that's a big it depends. There's nothing in the law about 10 years or 2 years.
Well,
you'd have to get a medical Go ahead.
Well, it would be a request for production, right? If they were questioning the cognizant abilities of the elderly person.
But it always has to be relevant to the allegation. I mean, you just don't have a right carte blanche to seize someone's
Right.
medical records.
Right.
It would be narrowed by the court to the relevant period of time. And what the relevant period of time is, if someone was incompetent because they had a terrible automobile accident, the relevant time would only be beginning at the time of injury. With competence brought on by dementia, it might be something entirely different. So it would depend entirely upon the unique facts of that person's alleged incompetence.
Yes, ma'am, I understand. Thank you.
Okay, we're ready to move on. I see you've already moved to the next slide. Going to update you a little bit about evictions and foreclosures.
And John, let me stop you just for a minute. We are almost to the witching hour here. You have 8 minutes, so fire away.
Well, and it's very, very confusing. People have no clue. And if you heard the news last Thursday, the United States Supreme Court ruled officially that the CDC had no authority to impose moratoriums on rent abatement and so on. So that'll be interesting to see. But anyway, as we understand it right now, the moratorium on evictions of people that have been foreclosed on goes through September 30th. The actual moratorium on the foreclosures ended July 31st, which meant starting August 1st, lenders could start sending out their letters of you're in default, you need to cure, and posting for foreclosure. And so that basically means that there's not going to be any foreclosures based upon this until the first Tuesday of October. You all know that foreclosures only happen on the first Tuesday of every month in Texas, and you've got to give a minimum 20 days certified mail notice before foreclosure can happen. So I wouldn't look for any foreclosures coming about until the first Tuesday in October. Now, lenders have been foreclosing, and they were authorized to foreclose throughout the entire pandemic time if they could prove the property was vacant, no one was in it. If it was abandoned or turned over to them, they could go through the foreclosure process, and they were not impeded by the requirements, the abatements and moratoriums that were put into place. So the question is there going to be I always hear this, is there going to be a big flood of foreclosures? Don't really know yet. It depends how many people who were affected by COVID-19 fell behind on their mortgages have actually been talking with their lender about options that were available to them. I have 2 clients I know of that we assisted in which, they lost their job, couldn't work for 8 or 9 months. They've now got another job that pays less, but we contacted the lender. The lender agreed to basically take 12 months of payments, didn't require them to pay it, but added it on at the end of the note. So the note, instead of being due in 2030, is now due in 2031. So they literally just have a 12-month period with no payments, no penalties, anything else. They just add it on to the end of the note. That's a pretty good indication that these lenders don't necessarily want to foreclose. Might be different in the market we have here in Travis County, Williamson County, but anyway, lenders are willing to work with people. They're willing to work with people only if they don't ignore them. They've got to be proactive in contacting them to work on a forbearance plan, delay payments, and so on. If they do that, they probably won't be foreclosed on. The people that will be initially foreclosed upon are the ones that have been ignoring all the letters, that haven't made payments for 18 months, and haven't contacted their lender at all. I guarantee you, those people, when they call, well, what can you do for me now? They're not going to get as receptive an ear at the lenders as people that were proactive throughout this period of time. As far as evictions on leases, My experience has been every justice of the peace does things a little bit differently. Supposedly, in Travis County anyway, the suspension of evictions is supposed to end on October 31st, 2021. Halloween, how appropriate. But they do it differently. I've had some eviction hearings in the past week or two. The JPs have handled it differently. Some have required a written notice from both the landlord and the tenant that they have both applied for rental assistance and after 5 months have not gotten it. If that happens, they will go forward with the with the eviction. If you file the eviction and ask for a hearing and nobody has done anything like that, the judge will abate it until the tenant and landlord are going through that process. But I think starting October 31st, there will be no longer any delays in evictions for any tenants, regardless of the reason. So I think that's the best update we can give you. It's a fluid situation, and it varies from precinct to precinct on JPs on how they handle it and when they want to schedule it. All JPs handle their own trial settings, so evictions, you can't necessarily just call and say, I want my eviction hearing set so-and-so. They handle it, they can abate it, they get full dockets, they can put it off if they want to. So it's done on a, district by district based upon the JPs in each county.
John, there's one question in the chat room, and I'm not sure I fully understand, but it says, don't most people have enough equity to avoid foreclosure?
I didn't follow that question.
I didn't either. So do most people have enough equity to avoid foreclosure?
Well, it's hard to say. In this market around here, the property values have gone up a quit. So yes, I mean, chances are anybody that's been behind their payments, they should have talked to a real estate agent, say, hey, what's my chances of selling before I get foreclosed on, and will I have equity? What's the market value? Yeah, there's a very good chance. I've had people come to me the day before foreclosure, and I ask them what they owe and I ask them what their properties were, and they got $200,000 equity in the property, and they made no attempt to avoid foreclosure by putting it on the market. Almost every lender I've dealt with, if the person signs just a listing agreement to sell it at a certain price, usually they will not go forward with the foreclosure. They don't all necessarily need a signed contract to close at that point. So, people just need to be aware of what their options are and not ignore it. But yeah, obviously, if there's equity in the property, getting the property listed normally will result in the lender not going forward with the foreclosure, and they can sell, get some equity, and decide what else they want to do. So, hope that answered the question.
Okay. Beth, I notice we're out of time for our official noon in, but we only have 2 more slides if you are okay with us continuing to go.
Absolutely. If you guys are, we are.
Okay.
Okay.
Go ahead, John.
Well, the next slide talks about, property owner as landlord or manager, and for foreclosures. Foreclosures get a little bit more difficult if the property being foreclosed on is not lived in by the owner, but it has tenants. There's a lot more notification required. And unfortunately, if a lender forecloses, even if there's a written lease with the owner, it is terminated by the foreclosure. A sale does not terminate a lease, but a foreclosure certainly does terminate that lease. And a lot of lenders are going around cash for keys. I'm sure you've been involved in one of those. And again, those are kind of very tricky things. Any agreement, cash for keys, should be in writing, signed by the parties, and sets forth a whole bunch of obligations, including a release of liability for the people turning over the property. I've been involved in some of those and made sure that we got a document in writing that handled all those issues. But I've also heard of situations where a representative of the lender comes up to the door and says, here's $2,000, I want the keys, and we won't foreclose, and we'll take it over. that ain't going to hack it. So you've got to have a written agreement for that. The other situation that comes up is a lot of people bought rental property, didn't divulge that they were going to rent it. I know that's hard to get away with sometimes, but those people may have a problem because they violated the due on sale clause, or they've created a fraud on the lender by making misrepresentations. And anything like that can give cause for a lender to exercise the due on sale clause and say they accelerate the note, the full amount is due, and if you don't pay it in 30 days, they'll foreclose on you. And we've actually had some of those situations where they made a misrepresentation on the loan applications. They were going to live there. They didn't. They immediately started renting it. Or they sold the property under some sort of alleged scheme of rent with the option to buy, or a contract for deed, or some of these other things around there. And that violates the due on sale clause, really subjects them to an immediate foreclosure. And I don't think courts are going to be very receptive to people arguing COVID issues if there's direct fraud on the lender and that sort of thing. So I think that kind of puts them behind the 8 ball, and they will get foreclosed on. The other issue to talk about on foreclosures is if someone is foreclosed upon, usually the deed of trust says they are a tenant at sufferance, which basically gives them no rights to the property until someone wants to take the property back. It's not really a month to month at that point. It's not anything else, just a tenant at sufferance, which means we will suffer you being there until we decide to do something about it. All right. Next slide is due diligence that works. You can save so much time by accessing these county sites to determine who's the record owner of the property, who's paying the taxes, so that you make sure you get all the right people to sign the listing agreement to sign. It's not uncommon to see a situation where a husband and wife are separated, one signs the listing agreement to sell, and you get to the closing table, and all of a sudden this other lady walks in and says, "Oh, I need to sign the papers because I'm his wife." We've seen all these weird things happen. It should never get that far. But by doing your due diligence up first as to who do you need to contact, who's record title owner, who else may have an interest, you can avoid all that. You need to find out if the property is in a trust. You need to find out if the property is listed in an LLC or a corporation. Is it still a viable entity? It is incredible how many people think they have an LLC or a corporation and they don't do the yearly paperwork or pay the necessary fees. They are inactive. If title is in the name of a corporation or LLC that's not active, guess what? They don't have the authority to do anything until they go back and be reinstated with the state. That can take some time depending on how long they allow that to go inactive. Laura, anything to add?
Yes, on trusts, many properties are held in trust, and the people who come to you and say they want you to be the listing agent, they have no idea what kind of trust it is. And that is particularly awkward. Many times these properties are here, but the people are in California or some other state, and it's a California trust. So you really need to insist these people give you the terms of the trust as it relates to the property. In many trusts, the property may not be sold in the way that you need to sell it or in the way they hope to sell it. So you just have to assume, and we're not talking about dummies here. A lot of the people that we're dealing with are very, very smart people. This whole weird world of what do trust bylaws say? What do LLC operating agreements say? And often whoever created all of that with operating agreements, they've just pulled it off the internet. And they don't realize that they have something where every member of the limited liability company or corporation in these small companies must agree to the sale. And they haven't even done the things that 3 or 4 months later, when you go over to the title company and the title company says, great, where's the operating agreement? Great. Where are the bylaws that authorize this trustee to sign this? They can't find them. And then you're going to have to go to court to prove up some of those things if they can't find them, unless every single party that's a beneficiary of the trust or an owner of any of the shares or the units of a limited liability company all agree. And try finding them all with these real estate investments. So many of the LLCs we're dealing with now for large pieces of land, the unit owners of the LLC are all over the world. They're families who have put 20,000 here and 20,000 there, adding up to several million, and there aren't any agreements, which means the LLC is not going to be enough. You're going to have to go back to those families. So we're here to help everybody get their deals out of the ditch and back on the rails and have a smooth closing. But you will say as much as there is for every one of you to do now, that's good work that'll pay you a commission and close, spending a little time when you get these listings, really digging into this, into all the things John's got up there, you will thank yourself for doing it. Because you got to have a plan long before somebody opens file at the title company. Because remember, when does the title company again check everything to see who the record title owners are? Usually 2 or 3 days before closing. So you really need to have a good, clear understanding both of legally who the record titles are with an entity or a trust. That could be a lot of different people. And then find out if there is likely to be any change in a trustee, change in the owners. Because these entities and trusts do not sit still. They change over time with deals that have got a long runway on them. Thank you, John. Yeah.
Okay, well, that gets us to the end. Are there any other questions?
Okay, well, I have 2 more things I want to say first. We have an incredible hard card that gives you links that will answer all your questions about everything. And when we send people links, they're not infomercials to articles our lawyers wrote that say, hire me, I'm the best. They're links to the Secretary of State, the Internal Revenue Service, things that are great. And you're smart enough, you know all this anyway. But these are great links to send your clients. And they're a buffer to protect you from a client who proceeds into these things with no real knowledge of it or educated about how things work in another state. Particularly, you're now in a position to give clients the happy news. Texas has no income tax. Texas has no state estate tax. And obviously, you don't want to dive too deep into taxation, but there is so much money being made when you help the seller that you really need to be thinking about how to get them help beforehand, and they will thank you for it. The second thing is we have, in addition to John Leone, who I will tell you, he's the best in Texas and maybe the world, and is one of only 29 lawyers now in the whole state of Texas that has not just board certified commercial real estate expertise by the state bar, but also is one of the few lawyers to have the brand new HOA, or rather Property Owner Association law certification. That's a big deal. John, you're a big deal there. But it's seriously though, we're here. If you will please remember, if you have a client who has a legal need, or if you as a JB Goodwin agent have a legal need, if you will just call us and be sure and tell our receptionist, I'm with JB Goodwin, you will receive your first consultation, unlimited in length at no charge. And many times with these people, they don't really need a lawyer. They just need to be told what to do. And we are for JB Goodwin happy to do that. Now, if they call up and they say, I don't know who my agent was, and let's be honest, half the time they don't remember John and me. They don't remember you because they're just trying to get some help. But if they tell us I was referred by a JB Goodwin agent, we'd rather know your name because we want to call you up and thank you and send you some cookies or something. But please remind them or yourself, tell our receptionist, because people who are with JB Goodwin, either a client or you, John Leone and I call you back. Some of you have gotten these calls at 10 at night. You get John's calls at 10 at night. You get my emails at 4 in the morning. So if it's JB Goodwin, we are responsive. And Maria wants the hard card too. Absolutely, Maria.
Well, Lauren, do you have the hard card in a digital format as well?
Yes, I do. So I'll send it to you, Beth, sometime this afternoon. You can just send it out along with the email.
Sounds good. Sounds great.
Okay, so again, as always, John, thank you. I learn from John, and I'm the one who wrote the PowerPoint because when Pavarotti sings, he sings extra choruses and encores. So that was great. And we're just so grateful that all of you could be here and go forth and prosper. Thank you, Beth.
Laura. Thank you, John.
All right, you're welcome. Bye.
Thank
Have a
you.
great day.
Bye-bye.
Thank you.